Okay, it appears that we are up and running. I'll go ahead and call the second case on the docket this morning. This is from Miami County. It's number 124-343 in the matter of the marriage of Joy L. Parrish and Brian K. Pippen. This case is set for 20-minute argument, counsel, if you want to use that amount of time. I believe that we have Mr. Dennis Clyde for the appellant. Is that correct?
Yes, Your Honor.
And Mr. Kirk May for the appellee?
Yes, Your Honor.
All right, Mr. Clyde, do you wish to reserve any of your time for rebuttal?
Yes, I'd like to reserve 5 minutes, please.
That will be granted. Again, you don't have to use up the entire time, but you're allowed up to 20 minutes if you wish to do that. And I do want to just begin, though, by reminding you that there's a jurisdiction issue in this case, which the court is interested in. So I would advise you perhaps to address that issue probably up front. Mr. Clyde, whenever you're ready to proceed.
Okay. Thank you, Your Honor. May it please the court, I'd like to start with setting forth what I believe are 6 well-established principles that help guide this case, and then I'll talk about the jurisdiction real quick. First of all, a lawyer's fee must be reasonable. Secondly, the Kansas Constitution vests the judicial power in the Supreme Court, the Court of Appeals, and the district courts, with the Supreme Court being the head of the judiciary with inherent power. Included within the judicial power is the Supreme Court's right to control, regulate, and supervise the practice of law. Licensed attorneys are officers of the court. The District Court of Miami County, Kansas is a court of original general jurisdiction, having the ability to hear and decide all civil and criminal matters. The Kansas Supreme Court has adopted KRPC 1.5 and its subparts governing the practice of law and ethical conduct of licensed Kansas attorneys. As for the jurisdictional aspect of the case, I truly believe, first of all, at one point, the court did rule on a motion to dismiss and found we complied with Rule 60-254, but I don't even think it's necessary. There was nothing left in the district court to be decided between Mr. Pippen and his attorney. I think clearly this qualifies as a final collateral order or a final judgment in any event, even though Judge Montgomery did certify it under the rule. I think it was a final appealable order regardless.
Mr. Clyde, let me begin with a question.
Uh-huh.
When I called this case this morning, you probably noticed I didn't mention the name Nick Lerner anywhere. And that's because he's not actually a party to this divorce case. Do you think that presents some sort of a jurisdictional problem?
Well, I'm going to honestly, candidly say, I just certainly hope not. I don't know how else Mr. Pippen would get this issue up in front of the Court of Appeals. I mean, it's not like he could have waited until all of the post-divorce proceedings were done. The divorce itself was final. If the rule has meaning, as I'm going to discuss, I don't see how he could have ever gotten Judge Montgomery's decision to decline reviewing the fee application before the Court of Appeals. I don't see any other vehicle. So I would like to hope.
Well, how about the Johnson County lawsuit that's pending, where both Pippen and Lerner are parties and discovery can take place and the court's ultimately going to rule on the issue? Wouldn't that be a good way to go?
Well, that's the whole point of why we're here, I think, and what I hope to address in my argument and have in the brief is that's a second litigation. And I think that if this is to have any purpose, that being Rule 1.5E, a second litigation needs to be avoided. The client, as I was going to discuss in Gillespie versus Seymour, the Kansas Supreme Court said the rule was drafted to give the client a mechanism for review of a disputed fee contract. Well, if he can't get that in front of the district judge that oversaw, supervised, and adjudicated the proceedings wherein the fees were generated, The rule just simply has no purpose then. So now we have to go to Johnson County in a second lawsuit and engage in extensive discovery and so forth. And it just seems to me that if that's going to be the case, then we may as well not have Rule 1.5E.
Is there any ruling we can make today that would do away with that second lawsuit?
Well, I think so. And I think, Judge Montgomery in his ruling actually, I think he was definitely struggling. And I think his comments show that if this court sends this back and reverses the order of dismissal, he was looking for some guidance. And, none of the 8 factors in Rule 1.5E require discovery. If you look at every one of them, there's nothing about that rule that requires certainly extensive discovery, if discovery at all. And of course, I've cited the rule in federal courts, which we don't have anything akin to that. Supreme Court Rule 7.07 allows the appellate courts to enter awards of fees on appeal. That's done on affidavit and time records. So I think, yes, I think what I'm hoping to see and what we hope to accomplish in this appeal for Mr. Pippen and others similarly situated, both now and in the future, is some indication of what the correct procedure is under Rule 1.5E. Does Mr. Lerner need extensive discovery to show the value of his services? Is that the procedure, or is it only on exceptional, extraordinary cases with good cause shown? Or, how does the district court proceed under Rule 1.5E? And our position is it's no different than when the district court's reviewing, for example, a settlement agreement in a wrongful death case, or fees in a Consumer Protection Act. To this point, at least in my practice, I've never seen parties engage in extensive discovery over a fee award. And I don't think, in my experience, I've seen it become the burden on the judiciary that I think Judge Montgomery, in his perspective, thought it would be.
Mr. Clyde, so in your estimation, then, would there not be able to be a contract dispute regarding the fee and fee arrangement?
Well, I think if I guess there could be, if Mr. Pippen had not asked for a Rule 1.5E application, submitted that to Judge Montgomery, and then Mr. Lerner withdrew completely and then filed suit against Mr. Pippen, then I suppose that could give rise to a contract dispute. But the way I read the rule, even then, even if we wound up in Johnson County in front of Judge Vano, there's nothing that prohibits Mr. Pippen from making the same application to Judge Vano. At some point, at the end of the day, if the rule has any meaning, a judge has to decide on application to review the reasonableness of the fees. And if it finds them unreasonable, then set and allow a reasonable fee.
The court did that in this case, though, right?
No. Well,
go ahead.
Yeah, I'm sorry. I think you're maybe referring to when Mr. Lerner made a fee application against the other party. There was a review of Mr. Lerner's fees in connection with that. There was never a review in connection with Mr. Pippen and Mr. Lerner's dispute.
Let me just ask you one final question on jurisdiction.
Yes.
You said we had a final decision to review. I'm struggling to try to find any decision that we have, much less a final one. The judge said he had permissive jurisdiction to review the fee issue, but he didn't want to do it in the divorce case because it would open a Pandora's box and complicate the case. And so he never actually reached the merits of the fee issue you're fighting about. He just declined to make a ruling. And so even 254B requires a final decision on one of the claims. Where do we have that in this case?
Okay. My response to that, Your Honor, would be that I believe when Judge Montgomery dismissed Mr. Pippen's fee application by refusing to review for the purposes stated, control of his docket, and he thought it would be better addressed in a second lawsuit. I think the Rule 1.5E, the way I read it, and that's one of the things I'm addressing today, is the very first sentence is I don't know if there'd be two clauses or not, but I haven't had a grammar class in so long, but I think the rule is clear and unambiguous. It starts out saying, upon application of a client, a fee contract shall be subject to review and approval by the court having appropriate jurisdiction. And I take subject to mean conditioned or dependent upon. Shall obviously is mandatory, much the same as we might say in this case that the issues are subject to Kansas law, or as I said before, a settlement agreement in a wrongful death case is subject to the approval of the court. I don't think Judge Montgomery had discretion to refuse to decline, to refuse to hear Mr. Pippen's application. And then the sentence goes on and it says, and then after it says, then it says the court shall have authority to determine whether the fee is reasonable. Now, there's where the discretion comes in. The trial court has the discretion to determine, is the fee reasonable or not? If it finds it's reasonable, then that's the end. If it finds it's not reasonable, then the last sentence, there's two full sentences in the rule. The last sentence says it must set and allow a reasonable fee. So I think what we're appealing from is clearly the dismissal of the fee application, which we think was mandatory. Under
The judge wanted more guidance from our court, right? He said that. That's why he certified 3 questions for interlocutory appeal. Is that correct?
Yes, my take on it was, Your Honor, that Judge Montgomery was if he undertook the review, he was stressed over what the correct procedure was. Mr. Lerner was arguing that he needed another lawsuit with extensive discovery. And if you look at Judge Montgomery's ruling, at one point, he even says he thinks it needs a second lawsuit with not only discovery, but the possibility of experts. And I think he used the words lots of factual testimony. So he clearly was anticipating much more than we think was called for under the rule, what was necessary to make a determination. The first time Judge Montgomery made that determination relative to the other party, none of that was necessary. Well, nothing changed. It's the same lawyer, it's the same client, it's the same time records, it's the same case. The only thing that changed was the first time Mr. Lerner was trying to collect some of his fees from Mrs. Parrish, and then the next time he's trying to collect the fees from his own client. So hopefully that answers the question.
You can continue.
Okay. Well, I think we've covered a lot of what I had to say. I'm going to add here that my viewpoint is in the district court, the issue was really quite narrow, raised by Mr. Lerner, and his motion to dismiss was simply whether or not the district court, sitting as a divorce court, had jurisdiction to hear Mr. Pippen's fee application. And then in conjunction with that argument, in his reply brief, Mr. Lerner said he thought he needed a second lawsuit with extensive discovery. Mr. Lerner did not raise as an issue in the court below whether or not Rule 1.5E applies to all contracts or only contingent fee contracts, nor did Mr. Lerner raise all the constitutional issues that have been raised for the first time in the appellee's brief. The ruling that's been appealed from is the ruling where Judge Montgomery said that he had what I call, quote, permissive jurisdiction, end of quote. I don't think that's really, I've not found the use of that term anywhere except in, as I mentioned in our brief, in forum non-convenient cases or clauses regarding where a lawsuit can be brought as a matter of contract. And so then he refused to, as we've discussed, he declined to hear it after he found he had permissive jurisdiction. Our position is the rule is quite clear and it was mandatory that the district court hear the application.
Counsel,
Uh-huh.
have you found any case that has approved the procedure that you're trying to use with Mr. Pippen and Mr. Lerner?
I have not. The closest thing I can come to, Your Honor, is the Kansas Legal Ethics Handbook, which we've cited in our brief, and the authors there clearly lay out what I believe to be the identical procedure that Mr. Pippen tried to use here. No one else, there's no reported decision that either side has found which is directly on point with this case.
And you mentioned the Gillespie case earlier.
Yes, sir.
Wasn't that a contingency fee contract?
Yes, it was. It was. The reason the Gillespie case was, go ahead, I'm sorry.
Well, my question is, isn't most of the case law interpreting Rule 1.5 involving contingency fee contracts?
I would say that's probably true.
And wouldn't you agree that divorces can't be done on a contingency fee contract?
Cannot be. That's correct. Yes.
Thank you.
I do believe that the rule itself is quite clear. It says all fee contracts shall be subject to review. And then, as you may have noticed in our brief, we quoted cited the Botwin versus Miller case. Now, that was the case where Mr. Botwin was challenging Mr. Miller's. Again, it was a fee contract, but Mr. Botwin argued that because it was subject to review under Rule 1.5E, there couldn't be any liquidated damages for purposes of prejudgment interest. And in direct response to that argument, the Supreme Court said it applies to all fee contracts. And therefore, if what you're arguing, Mr. Botwin, was true, it would be unreasonable, because that would mean there could never be liquidated damages in a fee contract case. So they were responding directly to that argument and said it applies to all fee contracts.
Well, let me ask you this question then. If Mr. Lerner was partially successful and the court found that he was in, I think the issue is the fees are at issue about 300,000.
I think
I'm sorry, Your Honor, you're cutting out on me.
Are the fees at issue about 300,000?
that's the balance remaining. I believe Mr. Pippen's already paid 147. Yeah.
I'm sorry.
Who's talking?
The other.
I think Mr. May is having trouble hearing.
All right. So let's just say the court determined that your client still owed $275,000 as an example.
Yes.
Would the court then have authority to grant judgment against your client in behalf of Mr. Lerner for collection of that fee?
I'm sorry.
Let me stop here.
Are you hearing me?
Yes, Mr. May, we can hear you. Are you hearing us? Apparently not.
I think I could hear him, and I think he said that was his problem. He wasn't hearing, that he wasn't getting the audio. Mr. May, can you hear me?
Mr. Clyde, can you hear me?
I can hear you. Yes.
Can you give me the thumbs up if you hear me?
There.
Mr. May, I take it you're not hearing me right now. Apparently not. I am not sure why we're having this difficulty. I haven't had this problem before.
It looks like he's all froze up now.
Yeah.
Should we take a recess, Kathleen?
Yes.
Well,
Let's not do anything with Mr. May not hearing. Why don't we?
Don't say maybe he could just call him directly.
Kathleen's contacted him already.
But he may not be paying attention to his email.